people. And thirdly, though, importantly, the Parliament will determine the functions, the operation, the structure of the Voice.
Minister for Indigenous Australians Linda Burney said that she would ask the Voice to focus on health, education, jobs and housing. But as Miss Burney knows, the Voice has no reason to listen to her. In fact, the Voice as a standalone entity in our Constitution would be able to do as it wishes, with its powers defined by the High Court, and could very well have more powers than an elected minister.
The way you've drafted this does mean, doesn't it, that future parliaments can change the powers and functions of the Voice, can make it less powerful, can make it more powerful.
We're a democratic nation, and parliaments are, in the end, they're the accountable body.
And you know what it says? It says, the Parliament shall have the power to decide what functions, powers and procedures the Voice will have.
It's an advisory body.
Parliament
does not trump the body.
Minister for Indigenous Australians Linda Burney said that she would ask the Voice to focus on health, education, jobs and housing. But as Miss Burney knows, the Voice has no reason to listen to her. In fact, the Voice as a standalone entity in our Constitution would be able to do as it wishes, with its powers defined by the High Court, and could very well have more powers than an elected minister.
It's going to be very difficult once we succeed for a government to ignore this Voice. It will be powerful when the people of Australia mandate that this First Nations voice must exist beyond the political cycles, because that's the goal here, is to set up a mechanism that actually exists despite the government of the day, and that's mandated by the people. So it is going to be, this is why we've had the fight for years, because they know how powerful this will be, and that's why we're asking you to walk with us. We need the 97% to apply that political pressure.
People. And thirdly, though, importantly, the Parliament will determine the functions, the operation, the structure of the Voice.
Straight talker. So when there's mixed messages around the Voice and what parts of our lives it will speak up about, listen to Megan Davis. The headline in The Australian over the weekend summed it up perfectly. Professor Megan Davis declares, "You won't shut the Voice up." Parliament will not be able to shut the Voice up, and the Indigenous body will speak to all parts of the government. This is according to the top referendum working group member Megan Davis. She says the Voice will be able to speak to the Cabinet, to ministers, to public servants, and to statutory officers and agencies. She even gives examples, including the Great Barrier Reef Marine Park Authority, the Ombudsman, Centrelink, and even the Reserve Bank of Australia. Professor Davis says this isn't to be feared. I'm sorry, but I think this will scare the living daylights out of people.
The problem with the current model for the Voice comes down to three associated issues. The first is the unlimited scope of the subject matter with which it can involve itself. The second is the fact that it will be empowered to make representations that reach into the executive branch of government and not just the Parliament. And the third is the fact that the High Court and not Parliament will have the final say on whether any limits can be imposed on the scope of its subject matter and its reach into the executive. Those who point out that the third clause in the proposed provision would give Parliament the power to make laws about the Voice's proposed powers have clearly missed the real point about that provision. At the moment, the power to make representations that reach into the executive branch is unlimited. The only limit on the scope of subject matter is that it must relate to Aboriginal and Torres Strait Islander peoples, and that is no limit at all, because Indigenous people, like all citizens, can be affected by all laws and policies, Tax laws can relate to Indigenous people, as do decisions about whether military alliances would expose citizens who happen to be Indigenous to the risk of enemy action. There is no requirement in the provision for the voice to be limited to matters that relate only or specifically to Aboriginal and Torres Strait Islander people. It's futile to argue that the new institution would never use its powers to involve itself in matters that are only that have only a marginal effect on Indigenous people. If that is the case, why give it the power to do so? While the new provision would give Parliament authority to make laws about the powers of the voice, that needs to be considered in context as well. The same clause that would give Parliament that power, Clause 3, also makes it clear that this power would be bestowed subject to this Constitution, and that invokes Chapter 3 of the Constitution, which vests the judicial power of the Commonwealth in the judiciary, not the Parliament. Parliament might try to make laws limiting the legal effect of representations by the voice, but those laws would be vulnerable to challenge if they infringe the powers of the judiciary. Once a provision is inserted into the Constitution, its meaning and the resulting implications become the ultimate responsibility of the court, not the Parliament. So, if, after the referendum, Parliament tries to legislate to limit the scope and reach of the voice, that legislation would be subject to interpretation by the court. And because the proposed constitutional provision contains no real limits on the scope and reach of the voice, any legislative attempt to impose restrictions after a successful referendum could, and probably would, be struck down as inconsistent with the unlimited reach and scope outlined in the constitutional provision. This raises the question about whether the government is really serious about preventing the voice from making representations to certain parts of the executive and preventing it from involving itself in certain public policy debates. At the moment, the explanatory memorandum to the Constitution Alteration (brackets Aboriginal and Torres Strait Islander Voice Bill makes a series of assertions about the second clause of the provision that are best described as speculative, if not courageous. It will be recalled that the unlimited nature of the second clause would empower the voice to make representations to Parliament and the Executive on matters relating to Aboriginal and Torres Strait Islander peoples. Yet at paragraph 14 of the notes to clauses, the memorandum asserts that Parliament and the Executive would not be required to wait for the voice to make a representation on matters before taking action, nor would the Executive be required to seek representations before enacting any law or making any decisions, at least according to that document. The basis for these assertions is not provided. Now consider how this might be presented to the High Court. If the Constitution empowers the voice to make representations, surely that would give rise to an implication that the representations should be listened to. And if representations are to be made, surely there would be another implication that the voice should be provided with information about pending decisions. Otherwise, how would it be possible to make representations in the first place? The reality is that the referendum would amount to a massive transfer of policy-making power from Parliament to the High Court. That needs to be clearly understood before we vote on this proposal.